Sunny, nice to meet you.
It's like I'm moving in and I'm going to live here. Always come a little too much here.
I have moved one out of that. Yeah, I have moved that out for now.
Not a lot of calendars. I like to see it in writing. Were you going to call me back?
Sure. There's only 14.
I know.
Yes, I can. Yeah. Put it up. Okay. Oh, I see. Oh, I got it. Yeah, I'll send myself this. Okay, yeah.
The other people don't want to send their
Oh, yeah, I didn't think about people downloading them. I always just like look through it up and stuff. I know what it is. Then.
Yeah, I tend to store stuff if I want it later. See how on the website.
I'll take it. For partisan gerrymandering or being ready for Covington? I don't know what it's for Covington. I don't know how it's going to work. There's going to be rulers and briefs. So, well, Dixon was hurt by that kind of sport. Yeah, so I don't know if it's burger. I don't think we've had any.
Yeah, I thought the board, I thought it was recently, I don't know, they actually on this.
We're going to post it.
So I know that is correct for so there's just one case, and that is going to be heard.
Hi, John. Good. How are you?
I could be released. The original was 17.
Which has
Oh, interesting.
Good afternoon, everyone. If you'll take a seat, please, the committee will come to order. We'll get started at this time. Before we move into our first presentation, I want to introduce our House Sergeant at Arms today. With us, we have Reggie Sills, Warren Hawkins, Young Bay, and Jim Moran. If you need anything, those gentlemen will be able to assist you in the committee. And members, please also go ahead and fill out your reimbursement form so that the Sergeant at Arms can collect those as well. At this time, we're going to start with our first item. We're going to hear a presentation and have a discussion on judicial redistricting and how that varies and is similar and different to legislative congressional redistricting. We will hear from my committee staff at this time, and after they're finished with the presentation, happy to take questions if committee members have questions.
In your handouts, you should have a chart entitled North Carolina Constitutional Provisions, Legislative and Judicial Districting. That's what we'll start talking from. So I think Jessica is going to get us started.
Representative Dewey.
Hold that up so we can see what we're supposed to be looking for. Thank you.
All right. My name is Jessica Sammons from Legislative Analysis. I'm going to go over the chart before you. It's called NC Constitutional Provisions, Legislative and Judicial Redistricting. And I'm just kind of going to highlight some of the differences between legislative redistricting and judicial redistricting, since we just finished a round of committee meetings in session on legislative redistricting. That's all fresh in your head, so I just want to highlight some differences as we kind of start talking about judicial redistricting. So beginning with the state constitutional authority for legislative redistricting, that is found in Article 2, Sections 3 and 5 of the North Carolina Constitution. As you can see, that's laid out for you in the chart. Basically, it says that senators and representatives shall be elected from districts, and the General Assembly at the first regular session convening after the return of the census every 10 years, the population that's taken, the General Assembly will revise the Senate and representative districts, and there's 4 requirements found in the Constitution to guide that process. The first is the number of senators and representatives. Each one will represent as nearly as close to an equal number of inhabitants as possible. Each Senate or representative district shall at all times consist of contiguous territory. The third provision is no county shall be divided in the formation of a Senate or representative district. That's commonly referred to as the whole county provision. And then when established, the district shall remain unaltered until the return of another decennial census of population taken by order of Congress. And so that's all found in the state constitution. For judicial redistricting, there's also constitutional provisions in place for that. In Article 4, Section 9, says that the General Assembly shall from time to time divide the state into a convenient number of superior court judicial districts. Article 4, Section 10 uses the same language for a district court districts. Article 4, Section 11 says the General Assembly may divide the state into a number of judicial divisions. And then Article 4, Section 18 says that the General Assembly shall from time to time divide the state into a convenient number of prosecutorial districts. And kind of the key things to remember as we're talking about judicial redistricting, the constitutional provisions directs the General Assembly to divide up the state, but it uses the phrase a convenient number of districts and from time to time as kind of the guidelines for that. Jumping down to the number of officials for legislative redistricting, as you know, there's 50 members in the Senate and 120 in the House, and that's all based on Article 2 of the Constitution. And as you know, that would require a constitutional amendment to change that. For the judicial redistricting, that's actually set out in statutes in Chapter 7A, and you can see those numbers broken down for each statute for Superior Court judge districts, special appointed Superior Court judges, elected district court judges, and then elected district attorneys. Those are all found in the statutes, and those numbers will be changed through the legislative process to change statutes. Jumping over to the second page, that is kind of where we get into equal population, and that's where the North Carolina Supreme Court has came in through court opinions and kind of gave some guidelines on that. As you know, the Stevenson versus Bartlett opinion in 2002 was kind of the main legislative redistricting case that shapes up how we interpret that whole county provision found in Article 2. The Supreme Court held that the whole county provision should be harmonized not only with the Voting Rights Act and the federal decisions of one person, one vote, but also with other requirements of the state constitution. And the court also said that the equal protection clause required a compelling governmental interest, and that absent that, all legislative districts should be single-member districts. However, the court did not say what compelling governmental interest would justify drawing multi-member districts. And then the court kind of sets forth a set of directions for drawing a House or Senate redistricting plan, and those are kind of laid out for you in the rest of that column. Kind of the main points of that is to ensure full compliance of the law. The court says that legislative districts required by the Voting Rights Act should be formed prior to creation of non-voting rights act districts, and that the trial court should ensure that Voting Rights Act districts are formed consistent with federal law and in a manner having no retrogressive effect upon minority voters. And then they also said that in forming new legislative districts, any deviation from the ideal population for a legislative district shall be at or within plus or minus 5% for purposes of compliance with federal one person, one vote requirements. Beyond that, the rest of the criteria for that case kind of goes into how you divide up using the population for whole county provisions, and then if you to stay within that ideal plus or minus 5% population range. And then the court also noted that communities of interest should be considered in the formation of compact and contiguous electoral districts. And then jumping over to the Blankenship versus Bartlett case for judicial redistricting. This case was in 2009. It was a ruling for a case brought regarding the Wake County following the 2000 federal decennial census. And I just wanted to take a few minutes to kind of go over some of the main points from that case as we begin to talk about judicial redistricting. The court said that the North Carolina Constitution North Carolina is under no mandate to give its citizens the right to vote for Superior Court judges. However, once it is done so in the Constitution, that provision must be construed in conjunction with the Equal Protection Clause. And so once the legal right to vote has been established, equal protection requires that the right to vote be administered equally. And then they went on to say that judicial districts will be sustained if the legislators' formulations advance important governmental interests unrelated to voter dilution and do not weaken voter strength substantially more than necessary to further those interests. And so kind of wanted to talk about what the court said with those regarding those important governmental interests. So while they didn't describe an exhaustive list of important governmental interests, they did note some which you heard from last week's presentation. So in addition to compliance with federal voting rights laws, legitimate factors for the legislator's consideration include geography, population density, convenience, the number of citizens in the district eligible to be judges, and the number and types of legal proceedings in a given area. So the court in Blankenship, in regards to what a plaintiff must show to kind of establish a case here for a violation of the equal protection, the court kind of emphasized that the plaintiff must make a prima facie showing of considerable disparity between similar situated districts in order to trigger constitutional review. And I just wanted to kind of highlight one of the final paragraphs of the case. They kind of talk about in this instant case before us regarding the Wake County Superior Court districts. There was 4 at the time, 10A, 10B, 10C, and 10D. And how this case kind of came about is the General Assembly had added an additional judge to the electoral district 10A, and the court was looking at the disparity in voters amongst those 4 electoral districts in Wake County, and found that District 10A, the voters elected 1 judge for about every 32,000 residents, while the voters of the other districts, 10B, 10C, and 10D, elect one judge per every, about 140,000, 158,000, and 123,000 residents. Thus, the court said residents of District 10A had a voting power roughly 5 times greater than residents of District 10C, 4.5 times greater than residents of District 10B, and 4 times greater than residents of District 10D. And then the court stated that no other subdivided district in the state comes close to the degree of disproportionality found in District 10. And then comparing District 10 with other dissimilar districts throughout the state, the voting strength disparity between District 10A and the subdivisions of District 10 is unique. And so they looked at the fact that District 10A had the lowest resident to judge ratio, while District 10C had the second highest resident to judge ratio. Looked at the rest of the state and found that no other districts that divided the county have a voting strength disparity among the districts remotely approaching the ratios found in District 10. And so they kind of saw that gross disparity and said that to make in this case, the plaintiff was able to demonstrate a disparity in voting power because of, looking at it compared to the rest of the state. But the court did say this is a phenomenon not currently present in any other judicial district in the state, according to the record before the court. And so they said the plaintiffs did make the required prima facie showing in this case, triggering the state's duty to demonstrate significant interest that justify the legislator's subdivisions within District 10, and to show the disparity in voter strength is not substantially greater than necessary to accommodate those interests. So the plaintiffs did make their prima facie case of showing the gross disparity, and so at that point it was sent back to the trial court for further review, focusing on the whether or not there was greater than necessary substantial interest to accommodate the interest of the disparity in voters. And so that's kind of an overview of the Blankenship case. And then if you flip to the third page of your chart, one more item at the bottom is the gubernatorial veto. And as you recall from the legislative redistricting plans are not subject to gubernatorial veto if it's in a bill that contains no other matter, and that's found in Article 2, Section 22. But to note that judicial redistricting, there is no exception from the veto found in the state constitution. So that is kind of an overview of the differences between legislative and judicial redistricting, as well as the Blankenship versus Bartlett case.
Questions from committee members this time about this presentation? Representative Jackson.
Thank you, Mr. Chairman. I mentioned last week having a question about if we go down this road of redrawing superior district court judgeships by population, how often will the General Assembly need to review that? Will we need to do it every 10 years as is done in legislative redistricting?
Churchill.
And I think the Blankenship case would be the one that would control that, and the Blankenship case is silent on that. The language in that case seems to be pretty specific to what was happening in Wake County following the return of the 2000 census. For those of you who were here in 2011, you'll remember the General Assembly did redraw those Superior Court judge districts in Wake County. And there's now 6 single-member districts instead of the 4 multi-member districts. But there's nothing in the case that would give any indication that the General Assembly, like with the Constitution for House and Senate, and with congressional districts according to the federal case law, has to review the judicial districts every 10 years upon the return of the census.
Additional questions from members? Representative Harrison.
Thank you, Mr. Chairman. Eric, would you mind repeating that last statement you just made? Apologize.
That's okay. So under the Constitution, North Carolina Constitution, for House and Senate legislative districts, it very specifically says they are to be revisited following the return of the federal decennial census. because of the equal population requirement. There is some case law coming out of federal court that has a similar requirement for constitutional, which is, that case law also gets you to the point that they have to be exactly equal, which is kind of the zeroed out component of a congressional map. The Blankenship case, in going through what was happening in the Wake County Superior Court districts in 2000, using those 2000 census populations, never imposed any type of requirement on the General Assembly to review all judicial districts periodically, and there is no requirement in the North Carolina Constitution to do so. It's just simply the General Assembly can draw for a convenient number of districts when they see fit.
A follow-up?
Follow-up?
So the Constitution says that the General Assembly shall from time to time divide the state to a convenient number of Superior Court districts. I just think time to time is interesting. If you have any idea what that means?
From time to time in the eyes of the General Assembly.
Okay, one last follow-up.
Follow-up?
Looking at the Superior Court districts in Guilford County, there's 5 of them, and I'm concerned about this because they vary substantially in population. One of them's got 128,000 using round numbers. One of them has 108,000, 85,000, 102,000. And one only has 62,000. I mean, do you have a reaction to that? I mean, is that something we should take a look at? Do you care to comment on that?
I would say just remember that the Superior Court districts and the District Court districts are not single member in the statute right now. So if you see a disparity in the population, the first question probably is, how many members does that district elect?
Thank you.
And in Guilford County, those are single member districts, so you've got, you obviously have a disparity there between the district, I think you said 128,000 versus 62,000. So certainly, a case to be made that it needs to be updated.
And Mr. Chairman, just a brief comment on that following up. Thank you, sir. Yeah, for me, that's a concern because if you're a voter in a district that only has 62,000, your vote counts a lot more than if you're a voter in a district that has 128,000. So just wanted to get that on the record. Thank you.
Representative Doolin?
Thank you, Mr. Chair. For the record, when was the last time the General Assembly, from quote unquote, from time to time, redistricted judicial districts?
I think that the answer to that lies in what you mean by districting. Periodically, the General Assembly has modified the prosecutorial districts, the district court districts, and the superior court districts. The last one of those being this summer in the budget process. But is an overhaul comprehensive review. I believe what you heard last week is that was a little over 60 years ago.
Thank you, Mr. Chair. 60 years was the answer I'll take. Appreciate it.
Any additional questions from members of the committee on this subject? All right. And we'll hear a brief presentation just to provide some background on our judicial divisions and how those have changed in recent years.
Mr. Chair, Gus Willis from the Legislative Analysis Division. So as part of my presentation, I want to present everybody with these 3 charts. They're all similar looking. And the most important thing, they're pretty self-explanatory, but the most important thing is just that we get them in order. So of these 3 charts, the first one, the heading is SL's 1969-1190. And then it's followed by SL 1999-396. And then the third one is GS 7A-41, which, just going through these, you can see the first one was 1969 when the 4 divisions were created in the statute. You look at the left-hand column, it's nice and clean, because that's when the districts were created, 1 through 30. And to your right is what counties were in each district. The next major change with the divisions came in 1999 when those 4 divisions were expanded to 8 divisions. And that's what your second chart shows, is what counties wound up where as part of that reorganization. And then your third chart is how things are currently as they will be effective January 1, 2019, as Ms. Churchill just mentioned, there was a tweak to District 9A in the budget process, and that's reflected in this chart, this last chart. Any questions, I'll have to take those.
Questions from committee members? More information provided? Okay, thank you. All right, this time the committee is going to hear from several interested parties that we want to certainly get feedback from, hear their thoughts on judicial redistricting potential plans. And we're going to start with the district court judges. I believe they have Judge Athena Brooks, who's the Chief District Court Judge from District 29B. Judge Brooks, thanks for being here today. And if Labor pause for 1 second. Representative Jackson. Yes, sir.
Mr. Chairman, we don't have an agenda. Maybe if you could lay out the agenda for today's meeting, try to figure out if I want to ask questions.
Representative Jackson, we're going to hear from a number of judges and individuals from the State Bar Association, Superior Court Judge, and then we're going to have a review of the current edition of House Bill 717 that passed, J1, and committee discussion. That's the remainder of what's on today's agenda. Yes, sir.
And were the judges that are speaking, were they selected by the bar, or were they invited by the committee, or
They were invited by the committee. We reached out to I believe the district court judges have a conference association. There's a Superior Court. We reached out as well to the clerks. They have their conference starting, I believe, today. We're unable to be here. Same for State Bar Association, and the Conference of District Attorneys. So they were all invited to come today before the committee to give their thoughts. Judge Brooks, thank you again for being with us today, and you have the floor.
Thank you.
Good afternoon. I'm Athena Fox Brooks. I'm the Chief District Court Judge from District 29B, which is Henderson, Transylvania, and Polk counties. I'm the immediate past president of the North Carolina District Court Judges Association. Our current president is Judge Elizabeth Heath. She's currently in our juvenile abuse collective dependency court with 27 cases, and unfortunately couldn't be here with us today. I'm also a Republican, and I am in a district who is not affected by House Bill 717. I am here today to speak to you as to what is best for the administration of law and justice for the court system here in North Carolina. There are 25 volumes of the North Carolina General Statutes. There are 369 books of case reporters for the North Carolina Supreme Court for its 198 years it's been hearing cases. There are 242 case reporters of decisions for the 50 years that the Court of Appeals has been hearing cases. Today, there are 272 district court judges in your 100 counties hearing cases and applying those laws and cases to their cases in the areas of criminal, both misdemeanors and felonies, juvenile delinquency cases, cases of abuse, neglect, and dependency of a juvenile, child support, child custody, divorce, equitable distribution, civil cases of all types, including jury trials, involuntary commitments, domestic violence, and restraining orders. The district court system was established over 50 years ago to unify the court system and guarantee the uniform administration of justice. It replaced the recorder courts and justice of the peace systems, which were not uniform across the state and did not promote the fundamental principles of fairness and equal access to justice across the state. Through the years, the districts have been modified as populations and needs have changed. One big influence was the racial justice modifications to some districts in the 60s and 70s. Recently, Becky Gray of the John Locke Foundation noted in her article in the Carolina Journal entitled Redrawing Judicial Districts, make sure we get it right. Changes to the judicial system that affect every North Carolinian deserve careful thought, advice from experts, thorough review, tough scrutiny, and thorough debate. As an aside, Ms. Gray points to the Courts Commission as the entity best equipped to handle this task. The Board of Directors of the North Carolina Association of District Court Judges adopted the following as our official position statement regarding House Bill 717. Although some realignment and redistricting in the courts might be needed, the process needs to be done in a transparent and orderly fashion, with input from a wide variety of citizens, legislators, and court officials. The maps as presented in House Bill 717 force turnover in a short period of time that will result in disruption to the bench and the administration of justice. In several districts, between 20 to 50% of the district court judges will be replaced by 2020, either by double bunking or by having their positions eliminated. These judges will be replaced without any regard to their fitness or job performance, which will result in the loss of years of judicial experience. The new districts which are drawn in these districts have few lawyers living in those districts. They are Republican leaning without many lawyers living in them. As a result, there will be few candidates to choose from for these positions. Further, as I can tell you about from my own district, when you split a judicial district, you tax the resources that are already in place. My district split in 2006. It split from 5 counties to 2 districts of 3 and 2. We did not get new judicial assistants. We didn't get new clerks. We didn't get new staff. So for over 10 years, for my 4 judges, I've had 1 judicial assistant, and she's had to manage about 2,500 cases. That's civil. That's not juvenile delinquency, abuse, neglect, dependency, and criminal. That's only the civil cases. Redistricting is a process which should be accomplished in a deliberate manner through a process which includes all judicial and legal stakeholders with the ultimate goal of the fair and impartial administration of law and justice always at the forefront of the process. We urge the committee to draw on the resources available to it, including the resources of AOC, which has not been involved, of the judges, lawyers, and lay people from across the state, and to make a systematic study of how the districts should be fashioned. The General Assembly is charged in the Constitution with establishing the districts for the district courts. With great power comes great responsibility. And here, that responsibility should be to ensure that justice continues to be fairly and impartially administered. The nature of law and conservatism is to proceed slowly while preserving the best of the past. In each of those district courts today sitting in those 100 counties, there are citizens of this state who expect their judge to listen to the facts, apply the law not as they wish it were or as they wish it might be, but as it is here today in this state. You expect those judges to do that in a deliberate, impartial, and thorough fashion. We, as the citizens of the state of North Carolina, expect our General Assembly to also make their decisions in a thorough and deliberate fashion, with a mind as to what is best for the administration of justice in the state of North Carolina.
Director Blunt. Gentlemen, we use this microphone.
And I don't know if this is for the speaker, the staff, or you, because I've heard now on a few occasions, not enough lawyers live in some of these districts. How do we know who's looking up all the lawyers and where their home addresses are? I know in Guilford, I'm a member of the bar, and I don't know nearly all the lawyers myself in a county like this. How how are we determining that there aren't many lawyers living in a particular proposed district?
Judge Brooks?
I can only speak to what I've heard in my district or a few other judges talk about. As you know, when you're a lawyer in the state of North Carolina, you can either register your home address or your office address with the state bar. I believe the gentleman is here from the North Carolina State Bar who can speak to this further. But in order to run for judge, you have to go and have the Board of Elections certify that you're a voter in a certain district. And that may or may not be the same address as the state bar. The information that we hear is that in certain of the districts that are drawn, there may or may not be 20 lawyers in that district versus the entire county may have more. I will have to defer that to perhaps Representative Stevens in the Courts Commission next Friday.
Did you have a follow-up, Representative Bluss, or? Okay. Representative Rogers?
Question of yourself. Judge Brooks mentioned the Courts Commission, and of course I'm on the Courts Commission. And I know we're meeting next Friday, and the agenda may already be set, but have you asked the Courts Commission to review this, look at it? Because I'm assuming Judge Brooks will be there and Judge Warden will be there, and we could get some more input that you may appreciate on the Courts, from the Courts Commission next Friday.
Representative Stevens?
Thank you, Mr. Chair, and I listened with interest as they were discussing the Blankenship case, because those are the very factors we're looking at. We do have the bar plan to come and speak about what addresses, based on the addresses, what lawyers live where or are situated where. We are looking at populations, we are looking at geographic distance, and we're also going to have a lot of public input.
Follow-up?
So it is on the agenda for next week, is that correct?
It is.
Thank you.
Representative Hardister?
Thank you, Mr. Chair. I have a technical question for staff.
Yes, sir.
I was wondering, is there a residency requirement? Does a candidate for judicial district have to live in that district?
Yes, that's correct. And staff says yes as well. And in those particular election districts in your county, that would be the same requirement there.
Thank you.
Representative Doolin?
Yes, sir. Thank you, Chair. I'm a little bit confused, Judge, and thank you for coming today. But at one point you had said office address and home address. And that's got me a little bit confused as to whether, for instance, my office and my home are still in my district. But tell me a little bit about that, or maybe the answer was just given.
I was only speaking for lawyers, but with the North Carolina State Bar, as a lawyer, I registered my office address because, quite frankly, I would like the public not to necessarily know where I sleep at night for safety reasons. So I don't register my home address with the State Bar, but I can register either one as a lawyer with the State Bar, home or office.
Follow-up?
Does that mean, though, that that office address has to be within the district for which you are trying to serve?
Now, that's two different things. That's a lawyer. As a judge, I have to live in the district from which I'm elected. When I go to file for election, I go and I have to go see the Board of Elections chair, and she certifies I am a registered voter in this district.
Follow-up?
Judge, thank you. I appreciate that. And I understand that better now as someone who's not a judge, but I appreciate y'all's service and understand that there has to be a little bit of a gap between where you live and where you work and where you serve. So thank you very much for your answer.
Representative Jackson?
Mr. Chairman, this might be for staff. Following up on the residency requirement, I was just wondering, are judges under the same residency restrictions that we are, and that you have to live in the district 1 year before the election?
Mr. Chair, no. So the requirement that a member of the North Carolina House or a member of the North Carolina Senate live in the district for 1 year prior to the election is a constitutional provision specific to the North Carolina General Assembly. What we're talking about now, where the judges have to live in the district that they're running in, is a separate requirement that you are disqualified to run for office if you are not a registered voter of that district.
Yes, sir. Follow-up?
So you would just have to be a resident of that district on the day you filed?
To be a qualified voter, you have to have lived in the precinct or the BTD for 30 days.
Yes, sir. Representative Jordan.
Thank you, Mr. Chairman. Following up on what the judge was discussing, I don't know if it's to staff or to the judge, but as legislators, we have to have our home addresses on available as public records. Do judges not have to do the same when they run?
Ms. Churchill.
Representative Jordan, the General Assembly for policy decisions has given multiple avenues for judicial officials to protect their home addresses at different places in time, such as the statement of economic interest that everybody files.
Any additional questions for Representative Corbett?
I'm sorry, I gotta ask it because the lady made a comment, the judge made a comment earlier, and I'm trying to draw some, I guess, similarity between that. You mentioned that if these maps were to go in, that some judges would be replaced and you'd be losing what we call constitutional knowledge or judicial knowledge. And that just struck something to me. Does that tell me that if you're a young judge or been on the bench a shorter period of time, or you're a judge that's been on the bench a longer period of time, you're better able to distribute justice if you're there longer than you're there shorter?
Depends. It depends your temperament, it depends on the case, it depends on some judges go in and they've been a lawyer 30 years, other judges go in and they've been a lawyer a year. The knowledge basis of all lawyers is sort of the same, but just as with your legislative members, a new freshman legislator is effective legislator, but they do things a little different than your more experienced legislator.
Mr. Chair. I understand that, but there's a difference, at least in my opinion, that here we are hearing issues and hearing problems and trying to address the needs of the people through the creation of legislation that hopefully remedies that concern or issue or problem. As a judge, it's my understanding that you take those laws, you read them, and you discern, hopefully at the same time each time, the outcome based on those laws. So you're not the creation of, you're kind of like reading and defining if someone went beyond the law or below the law. So when you mentioned being on the bench for a longer period of time, I was concerned that, to me, I was hearing justice may not be being distributed fairly if you've not been there for a long period of time, and that concerned me.
It would concern anybody. I think any judge that would be concerning. I agree with you. That's not what I said.
Okay.
Any additional follow-ups? Okay. Any other questions from committee members for Judge Brooks? Okay. John, thank you, Judge Brooks. This time we'll hear from Superior Court Judge Joe Crosswhite from District 22A. Judge Crosswhite, thank you for being with us today.
Representative Bard, Chairman Bard, thank you very much, and thank you to the other members of this committee for inviting us to be here. My name is Joe Crosswhite. I am the current president of the North Carolina Conference of Superior Court Judges. I do want to just point out from the outset that the Conference of Superior Court Judges, we're an educational conference. We're not structured. We're not a political organization. And it's in that light that I'm here. Again, I do want to thank this committee for the opportunity to be here. When House Bill 717 was first announced 2 months ago, several members of our organization addressed this body, and at that time urged the General Assembly, much in the same light as you just heard from the district court judges, to take a measured and collaborative approach to any changes in our districts and our division. And that has not changed. That continues to remain to be, that continues as our policy to this day. In the 2 months since, we've asked our members to get with their individual representatives where they live and to address their individual concerns and have those representatives bring the concerns to this body so they can be addressed at this level. There are, however, 49 judicial districts. There's 125 district court judges. We have 8 divisions, and I know that this process is continuing to go on. I know as recently as this morning, there were members of this committee talking with judges and other people about concerns in their particular area. We all fully understand that it is the job of the General Assembly to establish judicial districts and divisions, and I think we all respect that. I think this committee has a special skill set that no judge could bring to this table. However, there is a lot of experience and a lot of wisdom in the field where judges live and they know what is best for each individual district. For example, I'm from the 6th Division, which is in the middle of the state, and I cannot begin as the president of this conference to address the concerns that are either in the 1st Division down east or the 8th Division, which is out west. They all have their unique concerns that can only be addressed by the people that are on the ground. There is no need to rush this process. I think we just heard a little bit ago that the last major revision that we had to our districts happened over 60 years ago. So I'm urging this body just to take a measured approach, to do your research, to gather your facts, and to make a systematic, collaborative decision on what is going to be best for our court system. In a recent poll, the North Carolina court system was ranked 7th in the country in its legal climate. 2 of the reasons we ranked so high were because of our stability and our predictability in the system that we offered. I really went back and forth on whether or not I wanted to include this last portion of my remarks in here, but I decided, I think, to. Several years ago, I had the privilege to see a court system that did not have stability and did not have predictability. It was in Afghanistan, and I was there as part of the military. My job in Afghanistan was to help establish the courts in the southern part of the country. I got invited to watch a murder trial in the Helmand province, and they had been through multiple systems, multiple changes in the last couple of years. The defendant, as I indicated, was charged with murder. He had one witness, that was his mother, who can't even think that she could testify, but because she was a female, she could not testify. The judge, without a jury, heard about 5 minutes of evidence. They convicted the guy, the defendant, of murder, and the judge sentenced him to death. The defendant tried to appeal, but the judge, I think because of the other players there, was trying to present the appearance of stability, and he denied the defendant's appeal, and the defendant was executed 4 days after that. We are privileged in this country, and I tell juries after every single jury trial, and I've been doing it for 10 years now, that we are blessed to have the best form of government in our courts anywhere in this country. But we have that because we have stability and predictability. Our citizens know what to expect, and they know how to access justice. There are always rooms for improvement, and I know that's what this committee is attempting to do. And I don't think we are in any position to try to block that, but we want to just be a part of the conversation. We want to make sure this is a systematic and collaborative approach. We don't want anything to happen that's going to cause this to be destabilized or to cause us to go back. I guess the bottom line of my message is we don't need to rush to make any changes. We have the time, we have the luxury, we have the experts on the ground. We need to let this continue on and let everybody speak with their representatives and speak with the judges, gather the information, and make what changes they think are appropriate in a systematic and collective manner. My remarks have been short, but pending any questions from this body and this committee, I certainly will conclude my remarks.
Thank you, Judge. Questions for the judge? All right. No, thank you, sir.
Thank you very much.
Your time. All right. At this time, we're going to hear from the North Carolina State Bar and their legislative liaison, Peter Bolak.
Good afternoon. My name is Peter Bolak, and I'm the legislative liaison for the State Bar. And on behalf of State Bar President Mark Merritt and the rest of the North Carolina State Bar Council, I want to thank Chairman Burr and this committee for allowing us to speak today. The State Bar, which is the agency created by the legislature in 1933, exists to regulate the legal profession for the protection of the public. We do not generally advocate on political issues, funding issues, or judicial issues that fall outside of our regulatory responsibilities listed in Chapter 84 of the General Statutes. Advocacy on these issues on behalf of the legal profession is best left to individual lawyers, trade associations, and voluntary bars. Consequently, we take no position on any particular proposal in front of you today. However, the State Bar does have an interest in this process. Most directly, the State Bar Council, our governing body, is comprised of volunteer lawyers elected by their peers from each prosecutorial district across the state. Revisions to the prosecutorial districts will therefore impact our council and our local judicial district bars, and we stand prepared to quickly and efficiently adapt to any changes. One of the purposes for the State Bar, as stated in the State Bar's administrative rules, is the facilitation of the administration of justice. With that purpose in mind, the State Bar urges this committee to keep the effective administration of justice for the citizens of this state as your primary goal when considering proposed revisions to the district maps. We would urge that you be respectful of historical geographical boundaries in making your decisions and not split up counties in the creation of districts. We would also urge that voting on this matter be held over to the next session to allow all stakeholders time to review and provide input on these important decisions. This committee faces a difficult task, made even more difficult by the uneven geographic distribution of citizens and lawyers across the state. The State Bar has provided information regarding the geographic distribution of active lawyers in North Carolina and stands ready to provide any additional help or material this committee may need. Thank you for your time, and I'm always happy to answer any questions.
Thank you. I have one quick question for you, following up on some earlier comments. When you're providing that information about where active lawyers, which district they may reside in, or do you have the residence of those active lawyers, or are you using a business address? Are you able to determine that based on residence?
That's a good question, Chairman Burr. As what was said earlier by Judge Brooks, the State Bar maintains one address for lawyers as their official address of record in the state. Lawyers are permitted to use their home address or their business address. The extreme majority of the time, both of those addresses reside in the same prosecutorial district, but there are situations in which a lawyer may reside in one prosecutorial district yet practice in another one, and they are permitted to use the address in which they practice as their prosecutorial district of record, and therefore may not actually reside in that district. We don't have, as far as I know, the ability to guarantee the residency locations of all of the lawyers in the state at this moment.
So is it your opinion, or is it fair to say, I mean, you get into counties such as Forsyth or Guilford, Mecklenburg, where there may be there are residency districts or election districts there, and you have a particular election district that covers most of the downtown area surrounding the courthouse. And when we've heard comments made about a lot of active attorneys that it shows up, their address shows up as being there, and then you look at districts in the outer areas of the county, and they're saying there aren't any there, that it is very likely that that could be because those attorneys, those active attorneys, are using their office address rather than their residence with you all, and that information potentially is not accurate when you're talking about which district may have how many of our active attorneys in it.
Chairman Brad, what I would say is that we really wouldn't be able to know if a lawyer is using their business address. We have no way of knowing where they're living. Now, there could be still the predominant number of lawyers living in that election district. We just do not have that information if they're using their business address, and so we also have the ability to filter lawyers and do reports based off of a lawyer's noted zip code, but again, that could be their business address.
Okay, thank you. Representative Doolin.
Thank you, Chair. Question. When you say the term historical boundaries, you realize those go back 60 years without being touched?
Representative Doolin, I believe the intent of that is to respect the county lines and try to avoid doing as much splitting of inter-county, inside counties when making these districts.
Follow up?
Yes, sir. Thank you. Well, it turns out 60 years, it's every 60 years or so, you need to either get, you got to look at things and maybe move things around as appropriate. And even for lawyers. So, sir, thank you, sir, I appreciate your answer, but in my opinion, it is time, at 60 years, maybe we should take a look at this.
Representative Stevens?
Thank you, Mr. Chair. And I agree with you, it is definitely time to look at it, but it's to look at it carefully. And if I can ask the question of the speaker.
Yes, ma'am.
Ms. Bartlett, I am the one who requested the information about where lawyers live. And as you brought the information to me, we determined that perhaps the bar needs some ability to request both addresses, but we've got to do something to keep it confidential. Is that correct?
Yes, Representative Stevens, we would, if we want to protect where lawyers live and not make that completely publicly available information in addition to a lawyer's home business address, the bar would be willing to consider options and avenues to be able to collect two addresses, but we have not done so at this time.
And you would need some legislation basically for that in order to protect, because the judges are also attorneys, to protect residential addresses. Is that correct?
As far as my understanding of it, without having gone back and looking specifically at the statutes, if we collect information, we need to have a specific exception to keep it from being public record. And if we don't have that, then we would need some sort of permission in the statutes to allow us to have it be accepted from that statute.
Representative Doolin, you had a follow-up?
Yeah, actually, a comment, sir, Mr. Chair, thank you. It turns out, I agree that the judges, because they are out literally judging others, might need to have a little bit of anonymity. But attorneys, many attorneys in Charlotte, for instance, have their home addresses listed. Russell Robinson is my attorney and has been for my whole life. He's listed on his home address in the Charlotte telephone book, of which I will not say his home address, but I know it. My home address and my home telephone number are listed in the Charlotte telephone book if anybody needs to find me. An attorney who's doing business, many of you, and many of you might be attorneys, clearly put those numbers in there so folks that want to hire them get in there. Now, there might be a little bit of change for the judges, and I get that. But there's a difference between an attorney who's working a retail shop, whether it's a big shop or a small shop, and the judges.
Okay. My only response to that would be,
Go ahead, yes, sir.
We do have a contact number available for all lawyers, and so typically a lawyer, if they're trying to attract business, would want the client to be calling their law firm's number and not their home phone.
You have a follow-up?
Yeah, I mean, they're running a business, they have business and residence. Go through every phone book, and there's a business and a residence number in there. For goodness sakes, they're running a business.
Representative John?
Yes, Mr. Bullock, there are two statewide organizations, the North Carolina State Bar and the North Carolina Bar Association, and that creates some confusion, perhaps among certain members of the committee, certainly in the public. Could you briefly describe the differences between those two organizations?
Yes, sir. The North Carolina State Bar is the state agency created by statute to regulate the legal profession, and all active lawyers in North Carolina are required to be members and pay a annual membership dues to the North Carolina State Bar. Our focus is the protection of the public, so we do lawyer discipline and offer legal advice, ethics advice to lawyers and dealing with ethical situations. We do not engage in any kind of trade association activity, and that is where the North Carolina Bar Association, which is the voluntary trade association for lawyers, one of the largest voluntary trade association for lawyers in the state, and they engage in more legislative and advocacy issues than what we do, which is really limited to the regulation of the legal profession.
Follow-up, Representative John. Okay. Representative Moore?
Thank you, Mr. Chair. I would just briefly like to make a statement. I apologize for my tardiness. I agree with my colleague from Mecklenburg, Representative Doolin, Representative Stevens, that we very much need to look at the reconfiguration of these lines, but we also have to do it meticulously and methodically and with great thought, because we're talking about drastic change judiciary in North Carolina. And so we understand, cut my mic off, but we understand the three levels of government. We know that we make the laws. We know the executive branch executes the laws. And we also know that the judiciary interprets and holds those laws. So we have to be very, very sensitive and very, very mindful of the task that we're taking here. And I am in favor of taking this process into the next legislative session, or at least work until the short session, because guys, we need to get this right. We're talking about 60 years of we've done some tweaks, but we're talking about a major overhaul of our justice